You can completely follow the laws of your home country. You can never set foot in the United States. You can never have a transaction where your activity crosses into the United States. But because you aided and abetted, facilitated, and, in the words of the Department of Justice, conspired with U.S. taxpayers to avoid U.S. taxes, you are criminally liable in the United States. And we're going to enforce our laws on that kind of a basis. And I will say it's not even something I think that within the government is thought of as even extraterritorial. It's thought of as, we're enforcing our laws here because you caused a crime to commit here, a crime to be committed here, even though you didn't come here and you were in compliance with your own laws. I think we're going to have Tino and Tom talk about what that experience has been. And then Anne-Sophie's going to tell us a little bit about what the rest of the world is doing and what we all may be facing as that kind of approach. As people learn from us, for want of a better, and where that approach to tax enforcement is becoming a global mindset. And then we'll talk a little bit about some very specific programs that are out there, including the Yates Memo. But with that, I guess I'll kick it off to Tom and Tino, if you want to get us started on that dialogue.
Okay, Kathy, thank you very much for the nice introduction, and I'm very privileged to be sitting here with such esteemed colleagues, and we're the adversaries at this point, because we do deal with each other from time to time, and Tino and I work together on a lot of things, but it's really nice to be up here, and as I look back, it's been quite an interesting 10-year period for us in IRS. I think that international tax enforcement at every level of IRS is now the priority, and we see it in all the types of conferences we go to. We see it in the annual business plans that we put out. International tax administration is the priority in IRS. And just like that, we're no different. We're the smallest division, the criminal division. We may have the biggest hammer at times. And I think it's important to know, for you to know, that it is still priority number one for us. I don't know how many out there actually represent clients in this world. A show of hands, anybody, how many people out here actually represent clients in the world of international tax enforcement? Banks, shareholders? Okay. One of the things I want you to remember from what I'm going to say now is it comes from a quote from Preet Bharara, and as Kathy said, I was in New York for quite some time, and we had a very robust bank enforcement program there, one of the most robust in the country. And we made a lot of cases against a lot of banks. And one of the quotes in July of 2013 was in regard to Liechtensteinish Landsbank. Okay, and Preet said, the Southern District U.S. Attorney, said, today's agreement with LLB serves as another reminder for U.S. tax cheats who mistakenly believe that their offshore bank will never turn over their records or their account files to the U.S. authorities. To them we say, you can hide, but not forever. And that's the theme I want you all to remember, if anything from this talk. What Caroline said earlier, a couple panels back, we're getting records every single day. And there are, it's hard for me to understand and grasp the different avenues that we have at our disposal. And I was making notes of these things. So it's kind of important to understand where we came from, right? So back in 2000, before this was all that much of the forefront of what we do, we were working under the Qualified Intermediary Agreement program, and the banks had to report certain things about U.S. taxpayers and U.S. account holders. And that kind of necessitated the need to sort of de-obligate the banks from having to report. That was the point of having Swiss accounts, right? So they created these structures. And the Swiss bankers are very smart, and they did this, and they created the structures to hold ownership of the accounts, and then the U.S. taxpayers were the beneficial owners. So that went along for a while, and the government is trying to think of ways to ramp up the revenue collections. We knew Swiss bank accounts and foreign undisclosed accounts were important. We got that, we knew it, and I've been an agent for 25 years. Back when I started, we knew they existed, we just had no real mechanism to get them. Proceed along a few years, and they passed the whistleblower law. Again, Caroline, she took one of my items. The whistleblower law changes, and as she so eloquently described the statute, what was important was that people involved in these crimes could now also report. And I'm sure everybody in this room has heard of the guy named Bradley Birkenfeld, okay? $104 million later, Bradley Birkenfeld was the one responsible for a lot of the issues around UBS. And if that doesn't incentivize the whistleblower program, I don't know what does. So factor in whistleblowers. And I was even shocked at the amount of whistleblower claims that we get, because most of them we actually don't see in the criminal division. We see the big ones, but there are a ton of these things coming through. We go from the whistleblower in UBS, voluntary disclosures, 55,800 I believe we have now, 10 billion in collections, another 48,000 streamlined. For those people that say they were not willful, like Caroline said, we're still just getting our hands around that stuff. Again, I say, and not to sound too skeptical, at this point, people with undisclosed accounts, it's hard for me to comprehend that there are still people out there. And then many of these coming into this process, many of them are non-willful. And it was designed to fill in the gaps in this program to allow for this type of reporting. But there are, I'm sure, as we will find, potential cases in there where people were willful. Because who would want to pay 27.5 or 50%? When they can pay 5 or none or whatever it may be. So that's the incentive there. Just imagine though, 55,000, almost 56,000, and another 50,000 willful, non-willful streamlined. Think about the data that we've collected there. And I can tell you that a lot of our early stage investigations were developed through mining the data there, putting the links and the connections of this banker at this bank. That's what we did. That's how we made those cases, that information, okay? We'll skip ahead. In those investigations, I don't mean to skip ahead, we did things with Title 31 subpoenas, which were sort of a very novel approach to this, and it worked. And we were getting records from, under the required records doctrine in the criminal cases, getting records from the subjects of our investigations. That was amazing. Correspondent bank accounts, because again, having these accounts does nothing for anybody really if you want to use the money. How do you get the money back? How do you repatriate? How do you pay your bills? Those types of things. How do you use the money you've secreted away? FATCA, Swiss bank program.
I want to pause on the correspondent bank accounts because I've always thought this was one of the more powerful tools. And maybe we'll take a minute and explain what a correspondent bank account is and why it gets around the bank secrecy problem in a very effective way when you can get there.
Well, having your money set up in Switzerland, for example, kind of keeps it away from us. And it's the secrecy laws in Switzerland that protect that. But in order to conduct dollar transactions, which most people want to do, they have to get into the US, the dollar system, the US system. And many of these banks have these, what they call correspondent banks held in the United States to conduct their dollar transactions. And they're held in the US, which makes them available for us to try and compel the banks to turn this information over. And then we get piles and dumps of data about all of these banking transactions, and then what we do in the IRS criminal division is follow the money and follow the value. And we follow these things, and you know, people use it for everyday payment of bills. You know, for example, just paying your rent in New York City, we've had people doing that. So we get the correspondent account records, and we can see payments being made. And then we go out and we do our, you know, gumshoe detective work and find out that John Doe, this account holder, was paying his rent with money from a Swiss account. And that's a very simple sort of example of how that information. So we pile all that into our databases.
Yeah. And the two things I think account holders don't realize is they do a transaction in US dollars, or they do a transaction to make a payment here from what they think is that secret account, and they don't actually know that that is moving through a US bank, because it's not visible it's opaque to them that it's moving through a US bank.
And again, they just send a note.
And when Tom said, and we try to get it from the bank, well, there's no resistance. I mean, that's like that. Okay,
Not any longer.
That, you know, that John Doe summons goes out, that subpoena goes out, and those records are coming back because there's no bank secrecy law in the United States, and there's no barrier on that bank to be a good corporate citizen and comply with the third-party records that they've been asked for. You're not going to get that notice that goes out, oh, your records have been asked for. It's the John Doe summons. You're going to get all that record information back.
It's been a wealth of information that I can't under or overstate the importance of in making many of the criminal cases against the banks were done utilizing
very effectively
things
undercuts
like this. It's a
foreign
very,
bank
very
secrecy.
effective tool for us. Again, gets down to the idea that we're getting more and more information about these accounts. The treaty process, the tax treaty process, the MLAT process, because we can also get information based on MLATs for tax purposes, money laundering, things of illicit finance, all those things, collecting data again.
And that's another place I want to echo what Caroline said and follow up and kind of put my old hat on for a minute, because I used to come to these and people used to go, are you going to have a Swiss bank program for country X? You know, are you going to have a Swiss bank program for country? And I'd be like, we have all their records. You know, I mean, where the treaty is not like the Swiss treaty, and the Swiss treaty is unique, those records are just flowing in. So again, people kept waiting for a special program, and there was no need for one. Just got to thank you for Caroline over there.
And then the Swiss bank program, and I'll let Tino touch on that because that's a DOJ tax type of program, but our agents and our civil agents were working on that in conjunction and collaborating with them to develop cases and to deal with that information. And that's a tremendous, that may be the real significant piece to round this out. And what we talked about is the levers, and we all kind of look around, well, who made that word up, lever list? You know,
Swiss.
the lever list, the Swiss.
I'll say that
and
right
I can
now.
tell you,
that was the phrase they used.
They used
that phrase. It was not ours.
we had evidence and testimony from people, bankers and things of that nature, where they talked about that, and specifically how when UBS was being taken down and everyone knew it was happening, how the other banks kind of swooped in and said, hey, we don't have a U.S. presence. Bring it to us, bring it to us. And they actually tested the resolve of the Department of Justice as to whether or not we would bring cases against people that didn't have a presence here in the U.S. And obviously, looking back at it, that didn't hold water, that argument, and we made quite a bit of hay in going after the banks that didn't have a U.S. presence. Those are the types of things, but what's important to take out of this as well is, you know, your clients come to you and they tell you these things, right? They may not tell you, well, let's just put it in the context of non-willful. So you have a client that may be non-willful, but just keep in mind that we're looking at the actual account documents, the correspondence within the documents. You know, the things that we see that show that the particular account holders are acting in a knowledgeable and an intended way to conceal their wealth and income from the IRS. And you may not get that as, you know, you're getting the story on one side, but we actually are getting the documents. And the point here is that nothing is secret from us anymore. And it just may take a matter of time. We will get these things, and I have to say, part of my job now is dealing with many of the incoming MLAT requests and the outbound tax treaty requests. And it's weekly these things are going out. And I'll just turn it over to Tino in a second because my mouth's getting dry. I can say, you know, there's been a lot to be said about how the IRS is losing their resources. You know, over the year, the attrition rates for the criminal division are incredible. But at the same time, we're making less and less cases, right, per you know, because our shrinking workforce. But the level of international involvement has gone up. So it's kind of an inverse proportional relationship. It's really amazing because everything now is, and just think about how the global economy is. The borders have been knocked down. It's global financial. I mean, everything. You know, nowadays, you have a laptop and an internet connection. You can sit at your kitchen table in your pajamas and be an international business. Okay, and you can do your banking and you can do everything else. Those are the things we face now in the IRS. So it's amazing for me to look back over the years and see the difference in the world we're living in now. And being part of this at this point is incredible, but it's not over. And we've gone from Switzerland, and there's been enforcement actions taken in the Cayman Islands. Okay, and I'm not going to speak to where we're going next, but we're going somewhere next. Next bank, next country. That's the mantra we use. And again, with all of this information, our biggest problem is getting through it. We have so much to do, I can't tell you where we're going next. And it may be as simple as the next whistleblower calling us up. And as we proceed on into the new world and the big focus on beneficial ownership, we'll just see, based on what's going on in the news, we'll see where we go. But I'll turn it over to Tino now that I've
Before we do this, there's one other tool I want to comment on because Caroline commented on it and it doesn't get a lot of discussion. And it may be one of the most controversial tools available to the government, which is the Bank of Nova Scotia subpoena. Like Scott, I go back to when the original litigation was happening there. And when you talk about the government doing an audacious thing, you are talking about putting an entity that is in the United States, a bank, between the rock and hard place of the laws of another country and a court order from the United States. And there is obviously a balancing act there. But I thought the more interesting thing in that story, well, with the way they were talking about it, is UBS complied once there was a court order. And what we saw with Bank of Nova Scotia subpoenas back when it was the Bank of Nova Scotia is that the banks did not comply, and there were daily fines on the banks to try to compel that compliance. And what the government was actually getting was the punitive impact of that fine. But again, if the banks are actually going to comply once there's a court order with the Bank of Nova Scotia subpoena, that has become a far more powerful tool than it had been previously. And it ties again back into the correspondent bank account subpoenas, that you can get the information that's here that traditionally foreign secrecy laws were blocking, or you can get the information from someone who's here who will go get it now for you in a way where they used to resist. So that's the message. Caroline, you have something to add to that? Right. I mean, where you're seeing the U.S. located entity say, fine, I'll go get the foreign records once you take the step of giving me the right enforcement mechanism so that I can say I had to do it pursuant to this, that is a sea change from what happened in Bank of Nova Scotia and what happened in the historic Bank of Nova Scotia cases. And for a long time, I think, when Caroline talked about the balancing act of whether or not to bring a Bank of Nova Scotia case, part of that was, what am I going to get? If all I'm going to get is a bunch of money and an angry foreign government, why would I do it? And now you're getting, oh, thank you, you've given me a means to cooperate. And that is a dramatic sea change. In the short time between me and you, that is a dramatic sea change to see that happen with Bank of Nova Scotia. So Tino, I cut off the transition, the handoff, but join the conversation.
The easiest thing for me to say to keep myself out of trouble is to say, yeah, what Caroline said. So I know I don't cover beyond what I'm supposed to. But, I think what Caroline and what Tom said, closer to the ground, I see it every day. I think that institutions and individuals underestimate how much information we have. It's starting to change, and it's changing rapidly, but I can't tell you in my own experience, you sit down across the table from these folks, from account holders through institutions, and you explain to them what they know, what you know about them, and jaws drop. They don't understand how much the IRS and the Department of Justice, how much information we truly have, and how much time and resources that we're investigating. And when money leaves Switzerland, there was a long time, I think, where people thought, it's out of Switzerland now, I took it to country A, and country A has great laws of secrecy and I'm protected there. But we found it, and the IRS, to their credit, I mean, there's no agency better at following the money, and they follow it, and we work together to follow it, and we find those individuals, and when we do now, I think that they have really no argument, to say, oh, I didn't know about the F-bar, I didn't know I had to file or report this on this interest and gain on my tax return. They have gone from, Switzerland to God knows where, pretty soon they're 8 countries removed, and they've moved their money and their account 8 times. And you say, the gig is up, and like Tom said, quoting U.S. Attorney Barrara, we'll eventually find you, and it's getting exponentially worse, because you don't have that, to the extent you ever did, you don't have that argument that you just didn't know any better, especially when you're making multiple moves.
One question Tino and I whispered at each other while we were listening to Caroline that I want to follow up on. Caroline talked about going after taking a hard look at the streamlined cases that should not have been streamlined because there is willfulness in the acts of the taxpayer. And having been on both sides, on the government side and on the defense side, I applaud that, because having brought people into the OVDP program and having seen them pay those penalties, you don't want to think somebody else gamed the system and got away with it. And from the government point of view, that's paramount concern. Caroline alluded to the standard that may be considered, and could you say something about what statutes that might implicate? Because there's something we want to follow up on there.
Sure. So in talking about streamline, I think the question is if we see one of these that we know is a false streamline, what's a potential target's exposure? What are we looking at? What statutes are we investigating? The document itself is signed under penalties of perjury. So an easy one would be 72061, filing a false document. It's just not tax returns. That statute criminalizes any document filed with the IRS under penalties of perjury that's materially false and that the defendant knew was materially false when they did it. I think Caroline used the words, but it goes along with 7212A, corrupt endeavor to obstruct and impede the due administration of the internal revenue laws. To me, that's classic. You are filing a document under penalties of perjury saying, my conduct was non-willful, here's what I did, and it turns out that there was much more behind it. That, to me, is traditional obstruction, and I would be looking heavily at using 7212A to criminalize that conduct. And of course, then, even if the statute is otherwise expired, arguably it's an affirmative act of evasion that relates back to all those tax years. So your client just put tax years that we couldn't touch anymore back in play, and we have 6 years from the day that person signed that streamline to prosecute them for any year back to which that streamline covered.
Just to add, there's a separate form for that now. We actually have you sign a form that says that the failure to report the FBAR was due to non-willful conduct. So in addition to the jurat on the tax return, you have that separate form with that very same sort of language on it. So it actually provides us with quite a bit of ammunition if we have the underlying documents. And that's what I was mentioning before. We will have a lot of those documents to be able to compare to what your claim is. Or your client's claim, I should say. So we are in the process of looking at that stuff as well.
And before we move on, I want to focus on 7212A, because, and then let me preface this by saying what you should be hearing here is that if a taxpayer comes in through the Streamline program and they made a false statement in that, and they've said that they were non-willful on the underlying facts, and all of the evidence that Tino and Tom have said the government has available to it establishes that was a false statement. You've kicked open the door on the statute of limitations, but 7212A differs from all other tax crimes, because all other tax crimes for all other tax crimes there is a willfulness standard. The government is required to show a voluntary and intentional violation of a known legal duty. That is a high standard. It is a principle in criminal tax enforcement that a mistake, recklessness, negligence, a misunderstanding of the law, these things are not sufficient for criminal. You have to have known what the legal standard was, and you have to deliberately have violated it. 7212A does not have that standard. The standard is corruptly endeavored. It is less than willful. And it's just an easier statute for the government to prove. And the way, there has been controversy over the use of 7212A over the years, but I think almost everybody has understood it to mean if there is an ongoing investigation known to the taxpayer or an ongoing interaction with the IRS known to the taxpayer, and you make a misrepresentation in that, you've exposed yourself to 7212A, and that is the standard Caroline alluded to, and I just wanted to drive that point home.
Well, the one thing, though, that I would correct is absent even a difference of opinion in its own circuit, the Sixth Circuit, there does not need to be an ongoing IRS investigation for us to use 7212A. Here, because they're filing Streamline, there is likely some activity with IRS beyond just filing a 1040. But most circuits have said, most recently the Second Circuit has said that an ongoing investigation isn't necessary.
Like I said, it's a controversial statute, but it's an interesting tool that they have in this circumstance and that they're obviously planning to use. So, Anne-Sophie, since we've been doing all of this with some amount of glee to the rest of the world, what's the rest of the world starting to do?
Well, I don't know if it works. Well, in Europe also, over the last 5 years, we've noticed that the tax authorities have taken some drastic measures to better fight against tax evasion. What I'm saying, well, I'll talk a bit more in detail about France, but what I'm saying about France is also true in Germany, in Italy, based on discussion I've had with my colleagues. What we've noticed is that tax authorities are using much more than in the past the criminal proceedings or the search proceedings to fight tax evasion. There are three main targets: the wealthy individuals, so it's exactly the same situation as the one that was described. So basically, tax authorities got information from whistleblowers, and they are basically prosecuting every single individual who would not fix his own situation on a voluntary basis. But they are also targeting multinationals and financial institutions. And these last two cases are probably more interesting for that audience. For instance, as far as multinationals are concerned, all this starts from the premise that a number of multinationals are not paying their fair share of taxes in a number of European jurisdictions. And a number of European tax jurisdictions are trying to defeat the structures that have been set up by a number of US companies, for instance, that are based on an Irish or Luxembourg platform and that maintains a minimal level of taxable income in a number of other jurisdictions in Europe where the group operates. And so what we've noticed is that in those situations, which are should be mainly transfer pricing cases, the tax authorities have started to use, first tax rates and also criminal investigations. And obviously, this changes the type of audit that the tax authorities are conducting. And there have been highly publicized tax rates at a number of US companies all over Europe. So the purpose of those proceedings is to get a better access to information. For instance, under French law, the type of information and documents that the tax authorities can get access to in a normal tax audit are fairly limited, or much more limited than what the IRS could get based on your rules. And so obviously the tax rate is a way to get a much wider access to information. And for instance, the case law rules that French tax authorities can legitimately access to information that is stored on a non-French server, provided that that information is accessible from France. So basically, they could get access to all the internal memos or the files that could be stored in Ireland or in Luxembourg or even in the US, provided that the people in France get access to that information. What the tax authorities are trying to do through those proceedings is to try to establish that those multinationals maintained a French permanent establishment that they have not disclosed and for which they have not reported the taxable income in France. And that would be constitutive of tax fraud, and this is what would be subject to criminal prosecution. So tax rates can occur in two circumstances: either before any criminal investigation. The tax authorities have the right to go to a judge if there is some presumption of a tax fraud. So if they have some presumption, for instance, of an undisclosed permanent establishment, that would be the typical case for a US multinational. They go to the judge to get an authorization, a kind of warrant from the judge, and then they can search the offices of the French affiliate to try to establish that the foreign multinational is maintaining a permanent establishment at the premises of that affiliate. So that's the first situation we've been noticing. The other trend is that tax authorities are more and more often prosecuting the financial institutions because they are viewed. It's a question of tax policy. They basically take the view that those financial institutions, in a number of circumstances, have facilitated tax fraud or are facilitating the laundering of the tax fraud proceeds as a business, and so they are prosecuting those financial institutions. It's the case for UBS, it's the case for HSBC, both following the Swiss leaks, but there are also ongoing investigations in the context of the Panama Papers. And here again, the offense would be the alleged offense would be that those financial institutions have helped in the laundering of tax frauds, which, is a way to get access to the deep pocket, and which can result in very significant fines being charged, because they can represent up to 50% of the laundered proceeds, which obviously represent a very significant amount of money for the tax authorities.
I want to follow up just a little bit on something you said when we were in the prep session, because it's something I want to emphasize, because we began today by talking about how we in the United States looked at activities in other countries and said it had an effect here and we're going after you. So could you walk us through how, let's say, a hedge fund investor may find himself caught up in a criminal investigation?
Yeah, that's a very interesting and scary situation, you'll see. A number of investment funds who structure their real estate investment in France before the France-Luxembourg Treaty has been amended, was to set up a Luxembourg entity to hold real estate investment in France. And before its amendment, the France-Luxembourg tax treaty would allow a double exemption of the capital gain in case of the subsequent sale of real estate assets, because the French and Luxembourg authorities would interpret the treaty differently, leading to that double exemption, provided that the Luxembourg entity does not maintain a French permanent establishment in connection with that real estate asset. And so the French tax authorities have basically audited a number of those structures and taken the view that the way those structures were operated was such that they had maintained a French permanent establishment. And so this could have been dealt with in a very simple way, which would be to reassess the Luxembourg company, send a reassessment notice to the Luxembourg company and ask it to pay French tax on the capital gain. The problem is that in most cases, those Luxembourg vehicles, which were special purpose vehicles, were liquidated just after the sale of the real estate. And so when the French tax authorities realized that there had been a permanent establishment, the company was no longer there to pay the tax. And so they decided to use the criminal proceedings as an enforcement tool. And by turning those cases into criminal cases, for instance, they've prosecuted the former officers of those Luxembourg vehicles, although those vehicles were liquidated. And who were those former officers of those vehicles? Well, in certain cases, these were the key guys at some US investment firms, and so those people are being prosecuted in France for having been an officer of a Luxembourg company who failed to report a permanent establishment in France. And so obviously it's a way to enforce the tax audit more efficiently. You could think that the tax authorities are using this as a way to negotiate, but it's not even the case, because the opportunity you have to negotiate with the tax authorities is fairly limited. You have to do it before they turn the case into a criminal case, because once they have initiated, once the case has turned into a criminal case and there is a criminal investigation, then French tax authorities are prohibited by French law to settle the case. So once it's criminal, well, you just have to wait for the decision. The French tax authority lose their opportunity to settle the case. So there's a when they threat you to turn it into a criminal case, that's where you have to settle the case. After that, it's too late.
So in other words, you may have a transaction that you enter into thinking, worst case scenario, at the end of the day, you may have a transfer pricing dispute. And worst case scenario at the end of the day may mean that you are not a citizen, resident, or even present in that other country, but you are an individual under criminal investigation in that other country.
Right.
Okay, then. Now we know how the Swiss bankers felt. And so I guess to segue a little bit roughly, but a little bit of a segue because we promised to talk about this in the last few minutes. Speaking of the interaction between corporate investigations and what might befall the individuals, Tino, you want to take us through the sea change that is the Yates Memo?
Sure. So if you haven't heard of the Yates Memo, the Deputy Attorney General, I have it here, September 9th, 2015, so a little over a year ago, issued a memorandum addressing corporate compliance in terms of cooperation with Department of Justice investigations. Essentially, it requires corporations and entities, institutions of any type, financial institutions, who are under investigation, who want to cooperate with the government's investigation, to provide information on the culpable individuals within those entities. And I think what Kathy refers to as a big sea change is in Sally Yates's memorandum, she made very clear that it's an all or nothing proposition with respect to cooperation. If you want the department to consider your institution, your corporation, for any cooperation credit, you have to spill the beans on the bad actors within that institution, that entity. And so, I read recently, I think that Deputy Attorney General Yates made remarks where, in various investigations, entities are bringing in what they call Yates binders to show what the bad conduct was and who committed the bad conduct within the organization. And I'll tell you that it's what we expect. We don't want entities to sit down across from us and say, we want cooperation. Look, the entity, we have cooperated with your investigation. We've admitted to the bad conduct, and we're willing, to pay a fine and settle this with whatever the appropriate disposition is. So give us cooperation. It is not going to happen unless they identify the people within that organization that came up with the policies, that implemented the fraud, and that executed the fraud. And if they're not giving us every individual that was part of that chain, they should not expect any cooperation credit from us in reaching an appropriate disposition.
I will comment, and this is another one of those watching things shift over time. We were talking a little bit at lunch that certainly when I started, nobody cared in the government, who were prosecutors didn't care about the entities. I remember going in and offering entity pleas, and the response back would come from the prosecutor, I can't put a company in jail, and somebody did this, and I want the person responsible for doing this. We saw an evolution away from that to a sense that Sometimes things happen from corporate culture, from are pervasive through an entity, and that you really do need to hold the entity responsible, and that there has to be some appropriate remedy to the entity, even if the entity can't go to jail. And then what we watched, certainly over the last few years, is the demise of the too big to jail concept, as we've started to see the Department of Justice require guilty pleas from some companies, and even a deferred prosecution agreement won't do it. But there is the coming back around again to the idea that there needs to be individual culpability, and people need to be held responsible individually for what they've done. I'm going to pass on this, but we could talk for a while about what role that puts you in if you're representing the entity or the individual, and how you sort that out, and how well will a company be able to conduct its internal investigation if everyone knows that they're going to be turned in. It even has ethical questions about who is your client, in sorting through whether the person that you might actually be directly interacting with is at risk, and sorting out all of those issues, which is a panel unto itself, but it's an interesting challenge. You have a question? I thought you were supposed to hold up a sign and tell us, but, okay.
I'm curious as to Anne-Sophie's reaction to this in terms of the French perspective on prosecuting companies versus individuals, and companies cooperating against their employees, whether there's the same sort of tension there on that issue.
We don't have the same concept of cooperation yet. There's a draft law being discussed that tends to implement into French law a concept of DPA that would apply to corporations, not to individuals. So we're moving towards the same kind of situation. I think we noticed two types of situations. There are situations where tax authorities are trying to put pressures on individuals and to turn a number of cases into criminal cases to prosecute individuals in addition to corporations, because when individuals are being prosecuted, corporates tend to take the issue a bit more seriously than it's only tax at stake. Let's put it this way. And on the other hand, when the primary target of the criminal proceeding is the individual, like the wealthy individuals, they also tend to extend it to other corporate players, like the financial institutions. So it depends on the circumstances, but involving both individual and corporates brings more attention to the issue. Let's put it this way.
Thank you. Any other questions? Final comments?
I'll just say, I think with respect to the Yates Memo, corporations and their individual wrongdoers are really playing a dangerous game if they don't come forward. Frankly, what the Yates Memo does, I think, in a lot of instances, is encourage the bad actors within those organizations to get separate counsel and reach out to us, because it's going to be a lot better for them to reach out to us as opposed to having their employer cooperate against them, and then what do they have left? I think both the entity and the individuals have a lot at risk, and it's a big game it's a big risk to just sort of sit back and take a posture of, well, we'll sit back and see what the government has. I think that both entity and individual are in a much better posture if they come forward proactively.
I think Tino said it very well. We have a question. We have a question.
Rich.
You were on both sides of this debate.
Which debate?
The Yates Memo and the cooperation issue. Do you sense now, as a result of the Yates Memo and that more aggressive stance of we have to give up everybody, that there is a new calculus on the taxpayers or the prospective corporation, the defendant side, in terms of, before we go down this road, is there any pushback that we should go down at all? Because that disclosure, because of the department's position, it's all about.
Yeah, I think that's going to be interesting to see how that evolves, because I think that's the significant change in the Yates Memo, as Tino said. We began the conversation by talking about the Swiss bank program, and if you look at the Swiss bank program, that was built in there. You have to tell us who the players were within the bank, and enough information that the government could go figure out who the account holders were. But there was a requirement that the internal players be identified and that the external facilitators be identified. If you look at some of the prosecutions that have been brought against entities, and you actually read the documents that, the plea agreements and things like that, you will see a frustration by the government at a lack of that kind of disclosure. So I think those pieces were built in there. But like Tino said, what the Yates Memo did was make it an all or nothing. And for those who don't know, the government has guidelines as to weighing different factors in terms of whether or not to bring criminal charges against an entity. And cooperation is one of the more significant ones. Now, the Yates Memo says you might still get a deferred prosecution agreement, you might still get non-prosecution even without the cooperation, but you're not going to get that cooperation credit at all. And I actually wonder, from the line prosecutor's point of view, how much it was good to have a little bit of discretion to say, okay, I want to come to a resolution with this entity where the Yates Memo makes it all or nothing. And I agree with you that from the defense side, there is that same equation. If they're not going to be happy with it, how much am I going to give them, or should I just hunker down and realize I'm not going to get the cooperation credit? That has to play itself out. And I think that's the most controversial part of the Yates Memo, is the all or nothing. The rest of it was where you were seeing the policy go anyway, and where underlying government interests have always been. I think it's fair to say.
I'm happy to have no discretion.
I'm sorry.
I'm happy to have no discretion.
No discretion.
Very happy. To have
On that happy note.
Yeah, I want to thank the panelists, and I particularly am fascinated by the way the world is learning from us, and we are learning from the world, and enforcement just gets tougher and tougher.
Thank you very much. That was great. Thank you. So we'll now move to a break.